There is a case, probably of no great importance, an opinion certainly confirmed by the fact that it has received absolutely no mention in the press at all. However, even the presiding judge, most recently, has taken the deliberate time and effort to note in but just a minute order, reserved primarily for administrative minutiae, that it has possessed a rather protracted history for unspecified reasons. And so I decided to check it out, stirred by at least a bit of curiosity, only to discover that it is a case that has been brought under the FOIA, or Freedom of Information Act. That is a relatively simple and not complex provision of the law, originally passed in the administration of Lyndon Johnson, that embraces the spirit of an open government and gives any person the right to request documents, with a few exceptions, from federal government agencies even as high as the White House, so that American citizens can be aware of the activities being undertaken by their government, of the people, by the people, and for the people, on anything from aliens at Area 51 to even top-secret government programs, like one particular case involving the United States Navy ship Hughes Glomar Explorer, a deep-sea drill ship platform that had been built for Project Azorian, a classified project in 1974 undertaken by the CIA, of all agencies, to attempt to recover the Soviet diesel-electric submarine K-129 that had sunk to a depth 3 miles below the surface in the Pacific Ocean, some 1,560 miles northwest of the Hawaiian Islands on March 8, 1968. The USS Halibut identified the wreck site, and the CIA crafted an elaborate and highly secretive plan to recover the submarine for intelligence purposes. And that was until someone found out. And this case, Philippi B. CIA, that had attempted to discover more details about this particular project, was responsible for what now FOIA experts describe as a Glomar statement, in which the official position of the federal government is that it can neither confirm nor deny. And this case, with a rather protracted history, quite singular, not even covered by the press, at least to an amateur sleuth, appears to possess all of the earmarks of deep and dark intrigue, especially with a high-profile defendant like the executive office of the president, reaching to the highest levels of power. The curious case of OMB FOIA number 21220 and its history, a document request, simple and not complex, to the White House that had been about the 220th received that year by the White House in the year 2021, March 23rd to be exact, hoping to gain a little more information about only the 220th virus to become a threat to mankind that had emerged from the most abundant biological particles in the world, only the 220th, that had first surfaced in China, at least surfaced in the press, and had become the cause of the pandemic declaration, the longest respiratory tract infection pandemic in history, exceeding by 1 year even the Spanish flu pandemic of 1918 and 1919, all because of what experts claim was attributed to only two likely scenarios: a natural spillover from an animal source to a human, or that it had, escaped. When dealing with the government, this is not a car dealership, pal, and aspects of administrative law. According to the former dean for the George Washington University School of Law, Blake Morant, a former U.S. Army JAG officer who had begun his career as a law professor after departing active duty in the Army in Virginia at a Tier 1 law school, the Washington and Lee University School of Law in Lexington. The primary case brought by any plaintiff in administrative law is ultimately only about one thing and one thing only. This is not a car dealership, pal. Due process. Due process. The Due Process Clause requires that every man or woman shall have the protection of his or her day in court. And in the simplicity of syllogistic expression, due process is merely the process that is due under particular circumstances and does not invariably mandate trial-type proceedings. However, the court had said in the Glomar Statement case involving some rather unusual circumstances that it is clear that the FOIA contemplates that the courts will resolve fundamental issues in contested cases on the basis of an in-camera or in-courtroom examination of the relevant documents, so that the judge might see what the government is reluctant to disclose. And in one infamous case in which one president had gone too far with his use of intelligence assets in what has been described as the cover-up being worse than the crime, a case involving a third-rate burglary at the Watergate, the court had promulgated the rule that absent a claim of a need to protect military, diplomatic, or sensitive national security secrets, we find it very difficult to accept the argument that even the very important interest and confidentiality of presidential communications is significantly diminished by production of such material for in-camera inspection with all of the protection that a district court will be obliged to provide. This is not a car dealership, pal. And the fundamental requisite of due process of law is the opportunity to be heard at a meaningful time and in a meaningful manner. Interesting words for this case with a rather protracted history, even acknowledged by the court. Justice delayed, one jurist said, is justice denied. But following this due process imperative, the Supreme Court has articulated the bright line rule without exceptions that in a rule of law, as we have, no power can be exerted by the United States government unless it be found in some express delegation of power, like a law, like a regulation, or in some power to be properly implied therefrom. And so in such an inquiry or examination or review, as always, we must begin with the words of the statute, creating the commission and delineating the government's powers. According to the FOIA, each agency, upon any request for records, shall determine within just 20 days, excepting Saturdays, Sundays, and legal public holidays, when people are not at work, after the receipt of any such request for documents under the FOIA, whether to comply with such request, and shall mandatorily and immediately notify the person making such request of such determination and the reasons therefor. In short, if you wanted to know about whatever you wanted to know about from your government and were to submit a request for documents on that topic, be they Fauci's emails or the effects of global climate change on the waters of South Carolina, within just 20 days, excluding Saturdays, Sundays, and legal public holidays, you should expect to receive the documents that you had requested. It does not get any simpler than that. Just 20 days. Count your fingers and count your toes, if necessary. 20 days. Less than a month. This is not a car dealership, pal. However, where there is a rule, there is always an exception. And under the FOIA, in unusual circumstances, extraordinary circumstances, the time limits prescribed may be extended by written notice to the person making such request, setting forth the unusual circumstances for such extension, so that they might examine these reasons and the date on which a determination is expected to be dispatched. And generally, no such notice shall specify a date that would result in an extension for more than 10 working days. So at most, you might have to wait just 30 working days and not 20 working days to receive the documents that you had requested in an envelope with your name on it and a stamp from your government. Too easy. Unusual circumstances that may cause a delay in a response are limited to only 3 possible scenarios. 1, 2, 3, and may be used only to the extent reasonably necessary to the proper processing of the particular requests. 1. The need to search for and collect the requested records from field facilities or other establishments that are separate from the office processing the request. 2. The need to search for, collect, and appropriately examine a voluminous amount of separate and distinct records which are demanded in a single request. So, your request might involve, in case 1, coordination with a whole lot of other offices. 2, you may be requesting a whole lot of documents that have to be reviewed to make sure that nothing goes out the door that is maybe classified or shouldn't be released. And 3rd, there may be a delay In an unusual circumstance where there is a need for consultation, which shall be conducted with all practicable speed, with another agency having a substantial interest in the determination of the request, or among two or more components of the agency having substantial subject matter interest therein. 3 possible reasons why your request might be delayed 10 more days. And so, applying these simple rules, we can now examine what happened to this FOIA request, OMB FOIA 21-220. The case with a rather protracted history, even acknowledged by the court, but not newsworthy enough, of course, for the press, that had been received by the White House on March 23rd, 2021. Not long after the pandemic declaration's first anniversary, which should have found some response, even a decision to withhold release of the requested documents, or a request for more time because of unusual circumstances. More likely than not, normally just one of the 9 possible exemptions from disclosure, no later than April 20th, 2021. Just 1 month before the president decided to task the intelligence community to redouble efforts to determine the proximal origins of a novel virus now responsible for claiming more lives than Hitler in the Holocaust in half the time. April 20th, 2021, because that deadline for still unknown reasons, however, has never occurred. And according to the White House, it was not until January 13th, 2022, the next year, that the Office of Management and Budget, OMB, the office responsible for administering the FOIA at the White House, had even begun to search for the documents that had been requested in March 2021, beyond a reasonable doubt, having told the deadline for response. After the buzzer, to most reasonable persons, 9 months is far longer than 20 to 30 days. Do the math. This is not a car dealership, pal. Now, getting back to the law. For what now? In what has become the 3rd attempt to begin litigation to receive a response to OMB FOIA number 21-220, which has been described to the court by attorneys for the White House as nothing more than an unadorned, the defendant unlawfully harmed me accusation that is ripe for dismissal. But according to the law, procedural due process extends potentially to any statutorily conferred benefit, whether or not it can be properly construed as a liberty or property interest. But it still requires the deprivation of some statutorily conferred benefit before it is implicated, like a right to information under the Freedom of Information Act. It doesn't get any easier than that. The courts have said on an issue of prominent importance in the upcoming elections that a statute which, while furthering a valid state interest, has the effect of placing a substantial obstacle in the path of a woman's choice in bodily autonomy cannot be considered a permissible means of serving its legitimate ends, and unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion impose an undue burden on that right. But here with OMB FOIA 21-220, this is a statutorily conferred right, under the FOIA, guaranteed to receive information about the government, from the government, of the people, by the people, and for the people within just 20 working days. At most, under unusual circumstances, 30 working days. But here, in derogation of that statutory right, passed by the Congress, signed by the President when the White House had neglected to even begin to search for the documents until 90 days later, the requester has been accused by the government, attorneys at the White House, blaming the victim of spinning bizarre conspiracy theories or fantastic government manipulations, characterized as inherently frivolous and subject to dismissal. A reasonable trier of fact, looking at the reasons preferred, would find them wholly without credence and unworthy of the same. And yet this is the same government that had waited until January 2024 to communicate in correspondence to the requesters that had only begun to search for the documents that had been requested in March 2021 until January 2022, 9 months after the request. After the first case to compel a response had been filed, reaching all the way to the United States Supreme Court, not once but twice, as well as 2 further litigations that had been brought to simply compel the White House to fulfill the promise that had been made to the requester under the FOIA. Normally, in not unusual circumstances, courts have said that bad faith can be established with direct or circumstantial evidence. But absent direct evidence, the record must reasonably give rise to an inference of intent or willfulness. Normally, in not unusual circumstances, courts have said good faith would be presumed in the absence of a showing to the contrary in the manner permitted by our cases. Under normal circumstances, courts have said good motives and belief in truth do not negate an inference of malice, but are relevant only in mitigation of punitive damages if the jury chooses to accord them weight. Normally, under the law, actual malice exists when the defendant knowingly commits misconduct or when engaged in action with reckless disregard for the life or property of others. And under normal circumstances, courts have promulgated the rule that intentional spoliation, often referred to as bad faith or willful spoliation, means that the party acted with a subjective purpose of concealing or destroying discoverable evidence, and willful ignorance is the equivalent of bad faith. Normally, a case brought under the FOIA is granted priority of action in a federal district court, which has complete jurisdiction to enjoin any government agency from withholding documents, even sua sponte, while the requester is deemed to have exhausted all of his or her other legal remedies, making injunctive relief appropriate. And normally our courts of appeals have generally limited the use of this spoliation instruction to only 2 circumstances. 1, the deliberate destruction of relevant evidence, and 2, as apparently here, the failure of a party to produce relevant evidence or to explain its non-production. Under the first circumstance, the party who has deliberately destroyed evidence is presumed to have done so because the evidence was unfavorable to its case. Under the second, as apparently here, the presumption arises because the party controlling the missing evidence cannot explain its failure to produce it. Still, as always, in deference doctrine, we review the evidence, both direct and circumstantial, together with the reasonable inferences to be drawn therefrom in the light most favorable to the government. However, it remains still rather odd that this case, with a protracted history, has gone entirely unnoticed without any statement at all, even from the White House, on an issue of such arguably significant importance. And under the law, prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does may be used as evidence against him, and that he has a right to the presence of an attorney, either retained or appointed by the court. Still, nevertheless, evidence of blight is admissible even if offered solely to prove the defendant's consciousness of guilt as to that predicate act. Moreover, a defendant is presumed to continue his involvement in a conspiracy unless he makes a substantial affirmative showing of withdrawal, abandonment, or defeat of the conspiratorial purpose. And mere cessation of activity in furtherance of the conspiracy is not sufficient to show withdrawal. While ignorance of a fact may sometimes be taken as evidence of want of criminal intent, not ignorance of the law will suffice. Whoever knowingly, with intent to influence, delay, or prevent the testimony of any person in an official proceeding shall be fined or imprisoned not more than 20 years or both a felony. This is not a car dealership, pal. If it is not in the contract, not even the president can do it. Are we clear? I said, are we clear?
This message was approved by Major Mike Webb. Honest. This has been a Filmways presentation, darling.
And y'all come back now. Yeah.